All right, so I'm going to go ahead and share my screen with Transaction Desk. If you have your computers, feel free to, um, for those that are in the office anyway, feel free to tag along uh, on that front. Looks like my screen is coming through. So today we're going to cover potential and necessary or necessary documents and potential documents that might be involved with the transaction. I sent out a list with the many addendums and subsequent documents that could be attributed to a transaction. And I'm going to go through them kind of in order of how I see them coming into play of when you present them. The very first one, we're going to have to get very comfortable with this buyer broker, especially with all the lawsuits that's going on. The state has indicated that you're not able to make compensation a part of the contract. With all the lawsuits that's going on, I foresee that going to be challenged as well. Washington has required, you're from Washington, so you know the rule change in January. So correct me if I'm wrong, Megan, but from my understanding in Washington, you have to have a buyer broker agreement or whatever their verbiage for it is in place and signed at the very beginning of working with them or at the earliest possible time to present this to them. So let's say you're in an open house, someone walks in. Well, at that point in time, you really don't have the opportunity to sit down and do a buyer broker agreement. But the next time you meet with them, you need to be prepared to be able to do that with them in Washington. A lot of folks stay clear of this buyer broker agreement. I'll be honest with you guys, 22 years, I can count the number of times I've used this one in one hand. But with all these lawsuits that's coming down the pike, I think this is going to be a little bit more crucial for our business to ensure that we get paid and also to kind of give us some protection against any legal ramifications that's coming down the pike. So understand our commissions are negotiable in every way, from the listing side of things as well as the buyer broker side of things. Now, no one is saying that you have to sell yourself short, right? You make a business decision how much you're wanting to receive, and feel free to stick to that decision. No one, at this point in time anyway, no one's allowed to force you to work for less than what you want to accept. So, now this buyer broker agreement, the best way to broach this subject, and I'll try and get through this pretty quick, is just to establish your value. And you do that by using the buyer broker or the buyer presentation that EXIT has in the resource center. Another resource I've included in your handouts is online at realestateCommissionFacts.com. And let me pull that up. I wanted to show that. So NAR put this out to kind of help agents explain how compensation works. So this is going to be a good document for all of us to kind of get familiar with, or a resource. And it gives facts about, compensation. So hopefully this is just another resource for you to be able to show your value to your clients. So with this buyer broker agreement, though, you may start getting clients that are questioning compensation due to these lawsuits. So all I can say is the more you know how to do your job, what your job consists of, the more you can relay that value to them. And that's going to be a topic that we cover later on as well, is how to broach this subject, how to present yourself with your value. So then that way, when this conversation comes up, you guys are ready for it. We'll do some role playing as well, because everyone loves the role play, right? Yeah. So we'll do some role playing just to get everyone kind of comfortable with that. So this buyer broker agreement is fairly straightforward. Obviously, you got names. Every contract has to have a begin and end date. The employment here, you're just going to mark the type of property that they're looking for. within the following geographic areas. You can just put the Phoenix metropolitan area for in the valley here. If they're going to be looking, if you think they're going to be getting down into, you know, Maricopa County, or not Maricopa County, Maricopa, Santan Valley, Florence, you know, just go ahead and, you know, I would just say put and surrounding areas. Okay. We don't have to get the specific city. My thought on this is the more precise we get, the more we're working our way out of a prospective compensation. If someone wanted to take us to court. The agency relationship, you're going to set that forth in the agency form, and we'll cover that in a second. If you want to charge a retainer, I see this coming into play as well with these compensation issues. If someone wants you to get in your vehicle and start burning gas, feel free to charge a retainer. That's a conversation that you want to have, and you can decide whether or not it's going to be credited against any other compensation as well, right? You know, I've never done this myself, but I see where, you know, if you want to show, hey, look, my time is just as valuable as yours, this is one way to do that. My resources are just as, you know, dear to me as they are to you. You can certainly charge a retainer fee and then apply that against any compensations. Property viewings, this is where the buyer's confirming that they're going to work with you exclusively. Due diligence is basically the buyer's going to act in good faith to buy a property, that they're not going to be wasting your time. Megan and I were just talking about this earlier today, where she's got a buyer that's kind of been hot and cold at times, would you say?
Yeah.
And it's really hard to get them off the fence all the times. And this, you're going to cover with them, hey, look, you know, you're serious about buying. We're going to be doing activities going to help you buy. So you're agreeing to do that. This is also going to, if someone wants to refuse to sign this, it's also going to be an indication of, one, their loyalty to you, and two, how motivated they are to buy a house, right? And so that'll start giving you an indication of whether you want to work with them or not. Here's the reference to the buyer advisory. It points to it. Compensation, obviously, this is where you're going to put down how much you want to get paid. Considering we're in an office, you know, Sherman antitrust doesn't apply to us. Well, yeah, so this is not going to be us contriving, but let's just say I want 3% commission, right? And then they agree to pay that within 30 days. So if you go out and you have to be prepared for these conversations and ready to make a business decision. If you're going out, there's a lot of agents out there not offering a 3% commission at this point for buyers. You have to have that conversation with your buyer. Are you going to hold to that 3%, or are you going to be willing to accept whatever is being offered in the MLS? Okay. And you can even cap that. So if you can say, hey, look, you know, I typically get 3%, but if they're offering me 2.5%, I'll take it. Understand there's also some agents out there that's only offering 2%. You have to come up with the other 0.5% in closing. So whenever you're getting them pre-qualified, make sure that those numbers are in that in consideration when you're checking the reserves. Make sure that they got the down payment, the necessary down payment and closing costs covered. Okay. Another way to deal with that too is if you know that they're short, you can ask for concessions if they're not needing concessions to close the deal. So if there's any additional terms, just kind of goes over equal housing opportunity. We're unable to discriminate. Other potential buyers, they understand that you're going to be working with other buyers, so you're not going to be restricted to working with them during this time frame. Alternative dispute resolution, much like in the contract, if you guys get into an argument or a debate over something, everyone agrees to go to dispute resolution as far as it pertains to commission on this front. Attorney's fees and costs, basically loser pays attorney's fees. And then if the Arizona law supersedes anything in this contract, Arizona law wins out. Copies and counterparts, some of this stuff we'll be covering in the purchase contract. But copies and counterparts is everyone agrees that a copy is as good as an original signature, and counterparts don't come into play anymore. Entire agreement, if we make any changes to this buyer broker agreement, we're allowed to do that. We just need to make sure that we point back to that as well. So that's going to be your first form that you encounter with a buyer. The next form is the buyer advisory. I'll cover this one super quick. Read this at your leisure, but this is going to go ahead and give is a resource for your buyers for terminology, places to find information. You know, there's common documents that they should review, physical conditions of the property that they should take into consideration, as well as what's going on around the home, different ways to get information about the property, other resources as well. And then they'll go into and give web addresses for these. So every buyer, this is required for every file with a buyer. So you might as well get that taken care of with the buyer broker agreement and the first time you meet with them, or in, you know, as soon as possible. All right, the next document is going to be the agency and election. Real estate agency and election. Now, when you go to queue this up in the in transaction desk, there's one for sellers and there's one for buyers. So just make sure that you select the appropriate one, because they block out the boxes. They'll block out the boxes to where you can't select for the other party. And I'll show you where that would happen later. So obviously here the firm is going to be the brokerage. It's going to be acting through you, the licensee. This disclosure is whenever you enter into discussions with a prospective client, you need to establish who you're working for. At one point in time in real estate, all agents were working for the seller because that's where the commission was coming from. So you would put a buyer in your vehicle. The buyer was expecting that you were going to be working on their behalf. In reality, you were supposed to be protecting the seller's best interest. So back in the mid 90s in Arizona, they came out with this ABR, the buyer representation, to where individuals could then represent the buyers. So NAR is offering the free ABR designation. I know I sent that email out. I would strongly encourage each of you to go ahead and get that designation as time permits. I think is it 12?
It's 12 hours.
12 hours of classes. And then there's also some requirements from productivity in representing buyers that you're going to have as well when you submit for the actual designation itself. So anyway, so as far as the agency is concerned, you're establishing the relationship between you and your client, and we need to go ahead and let the other party know what that relationship is going to be. So the buyer's broker, so basically you're working for the buyer, seller's broker, you're representing the seller. The broker representing both seller and buyer, which puts us in a limited door representation situation, which we do not allow here. Now, understand the limited door representation is any contract that names EXIT Realty Coannah is on the selling side and the buying side. That's still considered. I don't care whether it's Megan on one representing the buyer and Savannah representing the seller. That's still considered limited door representation. You'll need to get consent to limited door representation. That's the only time I allow it. Actually, I shouldn't have said I don't allow it. I allow that. If Megan has a buyer or has a listing and she decides to have a buyer come in, that's where I don't allow the limited door representation. The way to get around that is when you get down into, am I in the right form? Yeah. The way to do that is when you get down here, you choose who you're going to be more loyal to, right? So in this instance, let's just say that you're talking to a buyer on a listing. Well, you had that listing agreement in place before you met this buyer. You need to look and see what that relationship and how the court is going to view that. Because the court, if it ever gets to court, the judge is going to sit you down. Let's just say, Sierra, you've known this seller since you were 5. Okay. You told the buyer you're going to represent their best interest. You only met the buyer at the open house. You mean to tell me that you're going to represent the buyer to your best ability and protect their interest over this person you've known since you were 5? No law in the land is going to believe that. So to give you that separation, you want to select who you've got more loyalty to, right? And so if you've got a listing, that loyalty is to that seller, okay? And most times it's going to be a buyer that comes in an open house. You don't know from Adam. So you simply, not simply, but what you want to do is you don't want to represent the buyer as the buyer's broker. You want to represent the seller as seller's broker. So you want to check this box for your buyer. And then you can also check this box too. Now, I would have that conversation with that buyer, say, hey, look, this is my listing. I've committed to this seller to represent their interest, their best interest. Now, Mr. Buyer, I know you want to buy this house. I can still represent you. I only need you to do one thing for me. I have to be honest with you, I have to be fair with you, and I have to follow your legal directions. Do not tell me how high you're willing to pay for this house, because I will be required to let the seller know that. Just keep that to yourself. We'll have discussions about values. We'll have discussions about, strategies. I'm not able to tell you how low the seller's willing to go. Do not tell me how high you're willing to go at this point in time. And 9 times out of 10, the buyer is going to be okay with that. You've avoided limited door representation situation with this form right here, because you're telling the buyer, I'm representing the seller, not you. So if you run into that situation, feel free to, that's why this is different, February 24, because it used to only be 1 page.
If we do run into that situation, we can just refer out that buyer to somebody.
You can refer that buyer out to somebody, yes.
We could technically do it with someone in the office.
You can technically do it with someone in the office, and you can do a referral. You can get a referral fee for it. But that's up to you and your business decision. Have that conversation with me, and we can talk about the legal ramifications of you representing them. Obviously, I would want you to get as much compensation as possible. And if there's a way for us to secure that buyer on that contract for you, I'd like to do that. And I've been able to successfully, anytime I've been in that situation, I've always been able to get the buyer to understand, hey, look, I've known the seller for how long, so from a personal perspective, obviously my loyalty is to him, right? But I can commit this to you, and legally I'm required to be honest with you, forthright, and like we said before. So now here's the thing though, it's that whenever you're trying to negotiate that, the negotiations are a little tougher. I will say that. So be prepared for that if you get yourself into that situation. And then also the buyer is going to have some potentially have some unreasonable expectations of you during that process. Okay. So just be prepared for that. So it may be worth just referring out and just getting, a healthy, referral fee on that as well. So I'm going to go ahead and go into consent for limited door representation. So let's just say that you do decide to refer that out to somebody. You've got the consent to limited representation form, which is right here. So here you would just outline the buyer and the seller, indicate whether it's going to be through 1 license or 2 licenses. So 1 licensee would be if Savannah decided, hey, I'm going to do everything. I'm going to represent both, and both parties understand, that they're entering into a limited door representation, which we don't allow. So we just talked about that. But in the instance of you want to refer that out to somebody, you would select 2 licensees, and then you would name, Savannah and Sierra or whomever on that. So the duties and limitations is understanding the broker is the one representing both the buyer and seller. And so this kind of goes over what you can and cannot do. So you got to be mindful of what you share as far as pricing and terms are with the other party, right? So basically, you just want to start protecting your clients to the best of your ability at that point. And just, understand your buyer is your buyer, and the seller is the opposing, the cooperating agent's seller. And so enter that as you would any normal negotiation. And then we just need to, exercise reasonable skill and care, and be obligated to deal honestly with all parties. And then just they covers compensation. And then now understand, seller and buyer understands contract does not replace prior agreements. So whenever we are entering into contracts with buyers, just like we do with listings, we need to make sure that there's nothing in writing that that buyer is obligated to another agent. So we always ask those qualifying questions. Have you entered into another contract with somebody else? And if the answer no, probably wouldn't be a bad idea to come up with a form that says, you know, I've advised you, especially if you're not sure whether they're being totally forthright and honest with you. Just do a little document that says, hey, you know, I've been advised, you know, that if I have a buyer broker agreement with another agent, they may be due compensation as well. Okay. So if you run into somebody that you've never met before and you're a little curious or concerned whether or not they may have another buyer broker agreement with somebody else, you know, we can have that conversation and we can kind of draw up that little verbiage to kind of help cover your tail at that point in time. All right. So that's consent to limited door representation. We're down to market conditions advisory. This one's going to be super easy. Now, this one's required as well. The agency is required. The buyer advisory is required. The consent to limited door agency would be required if applicable. The market conditions advisory is required as well. I'll be able to cover this much quicker than I can pull it up. This is basically advising sellers and buyers. The market is cyclical. It goes up, it goes down. You make money, you lose money in real estate. And they understand that it is not you as a realtor's fault, that you do not control the market. So I know, right? You know, and here that brings me to a point with Manny's reaction. Sometimes I feel that way. You know, if I helped someone buy a house and then the market crashes and then they call you up and ask what their home's value is and it's less, you know, you take some ownership in that, which, you know, is a good thing, but a bad thing. You need to remember that we're not in control of the market. Okay. We can only help our clients make the best informed decision as the market dictates at that point in time, as, you know, as their needs are as well. So just be mindful on that front. And that is a required document. Another one is the wire fraud. So we had a little scare with that one yesterday. Wire fraud is on the rise. So this is a wire fraud advisory. Effectively, tell your clients whenever they're doing a wire to, if they receive directions from a title company, to pick the phone up and call that title company to confirm that those are valid wiring instructions. So, you know, just make sure, you know, that you tell your clients, hey, look, if you get wiring instructions, call me. You reach out to title, you know, the client reach out to title, and then you reach out to title and say, hey, look, I just want to make sure that you sent wiring instructions, that they get back with you to make sure that they were good. So a little scenario came up yesterday. I had a closing, another closing was supposed to happen yesterday. The buyers, not my buyer, but the buyers ordered the wire on Monday. Title didn't get it Monday night, but they wasn't worried about it because they didn't confirm wiring instructions until like 4 o'clock. So that's past the wiring deadline. Tuesday came, still no money. Wednesday came, I call in just to make sure everything's looking good. And they're like, well, the title company says, well, we don't have the buyer's closing funds yet. And they said, and it was sent Monday. So my immediate thought was, oh no, please tell me they called you to confirm that, you know, the wiring instructions. And she's like, yeah, they called me about 4 o'clock. She's like, so I know that they had the proper wiring instructions. Turned out they ended up doing the wire request online, and they requested an ACH versus a wire. ACH is basically a check, which according to what is it, the Good Funds, I can't remember what it's called, but Good Funds Act or Good Funds something, all payments have to be through a wire or certified funds money order. So those aren't any good. So now we're waiting for, the title company had to reject the ACH yesterday, and now the bank has to then redeposit those funds into their account to make them available and hopefully not hold them, and then release those funds to be able to be wired. So just little funny games there. But yeah, that was a little bit of a scare we had yesterday, because if their funds were stolen, then I didn't know whether or not that buyer would be able to perform. All right. Now, the next one that you would be coming along is the big one. This is the residential purchase contract. I'm going to very quickly go through this one. I will be giving my Reader's Digest version. We'll be covering how to fill this out properly whenever we circle back to this, and where we dive in a little bit deeper into this form. I actually had an offer come in yesterday where it was the sloppiest offer that I've seen. They didn't put down what the down payment was going to be. They didn't label what the new loan amount was. Yeah, it was just horrific as far as I was concerned anyway. So you've got earnest money, the form it's going to be in: personal check or wire or transfer. Close of escrow is going to be here. Possession is going to be typically at close of escrow. Here's all the addendums, and we'll be covering those as well. We'll be taking a look at that. Fixtures and personal properties. This is everything that's supposed to remain with the house. So if it takes a crowbar, screwdriver, or hammer to remove and or install, it's probably real property and should remain with the property when it sells. It's very important to have those conversations with those sellers. At the listing appointment, hey, look, if there's something hanging on the wall that you want to take with you, just go ahead and take it down to remove any confusion from the buyer who might expect that to stay with the house. And then if there are any leased items, solar, etc., if they're owned, they'll transfer as well. This is where they would need to request any of the appliances as well as any other personal property. And then this is additional existing personal property shall not be considered part of the premise and be transferred with no monetary value. So if your lender comes back and says, hey, that can't be in there because it gives a hint that there's monetary value in that, this, point your lender to this clause here, 63, 64. No. We just asked for it. There's no value in it. We just wanted it because we like what's up. Okay. And then see if that'll suffice. Sometimes it will. Sometimes the underwriter will come back and say, no, take it out. Then you just have a conversation with the seller. Financing, this is the entire financing section. The pre-qualifications included, loan contingency, it's contingent upon being approved for a loan. Unfulfilled loan contingency is what happens if they get canceled or if they get denied, earnest deposit gets returned to them. Interest rate necessary funds. It talks about basically whenever the seller or the buyer says, I've got 100,000 to put down, they actually have 100,000 available to them. Loan status update, they're allowed to get to contact the lender for updates. Type of financing, certain things that you need to make sure. Whenever you get offers as well, you want to make sure the type of financing lines up with the down payment that they're offering. So I got an offer last night on a listing. They're coming in conventional. Conventional, you can get 3% down, 5% down as well. FHA is 3.5%, and VA is no money down, right? So if you see an offer that comes through with FHA with no money down, there's a problem unless they're asking for down payment assistance. There are some DPA programs out there that will allow the buyer to come in with no money. Okay, so just things to consider. This is a big one that gets missed a lot. So seller concessions, if they're asking for help with money, with funds towards closing costs, okay? Changes need to be done in writing. Understand appraisal contingency. This is one of those other contingencies that buyers have, is if the appraisal doesn't come back, if it at or above the agreed purchase price. If that happens, do not drag your feet, guys. You only have 5 days to cancel the contract. So 9 times out of 10, what's going to happen is you're going to contact the appraiser. You're going to contest the value. The appraisers are going to give you a process to go through to contest it. That takes a long time. So just understand, be very mindful. At 5 days after that appraisal comes back, you need to to cancel or decide that you're going to come up with the difference. So make sure that you've got a relationship with a lender that's going to tell you the moment it comes back, because that's when that clock starts ticking. This is where we indicate who's going to be paying for appraisal costs. This one right here, I'm getting a little bit more in depth here than I wanted to, but this is if the appraisal is going to be considered in any concessions, if there's any concessions given. Title company, your favorite title company would go in there. This is basically everything the title company is going to be doing for you. Disclosures, this is, where the seller is required to give the spuds within 3 days, insurance claims history within 5 days. Now, let's talk about this real quick too. This is another deadline item where if your seller doesn't provide the spuds within 3 days, let's say that it takes them 7 days to get you the spuds. Well, you only have a 10-day inspection period. Okay. So day 10 comes, you're not really out of your inspection period, because if they give you the spuds, now from when they give you the spuds, you have another 5 days to accept or reject the spuds. So this is another out for your buyers if the seller doesn't supply that in a timely fashion. Same with the insurance claims history.
So in Washington, when I've had listings, I've had them just do that prior to going live on the
Mhm.
market. Is that, like, would that be a best practice? Just have them do it?
Yeah, best practice is to have your sellers complete the spuds and have that uploaded in documents. For FERPTA, lead-based paint disclosure, FERPTA doesn't apply a lot, but if it's involving a foreign, or a non-US citizen, buying or selling real estate, and I think it's more on the selling side of things. Lead-based paint disclosure, Sierra, what year is lead-based paint disclosure required? Very good, 78. Affidavit of disclosure, this doesn't apply very much, especially when we're dealing with properties in town. If a premise is in an unincorporated part of the county, there's 5 or fewer parcels, other than already subdivided, this would apply. So that rarely is going to come into play. Warranties, exchange the word warranty with promise. Basically, all contracts went to as is a few years ago. So just, buyer beware. And we'll get into this contract a little bit more in depth at the back end of the training, probably next week or the week after. Inspection periods, and that's when we'll start talking a little bit about strategies and such. Inspection periods, 10 days, everything that you can inspect for, square footage, wood destroying termites or organisms, sewer, septic, basically everything you can inspect for. Home warranty plan, walkthroughs. Well, who's gonna pay for the home warranty versus who's gonna order it as well. Or you can decline the warranty. Walkthrough that is authorized prior to closing. Seller's still supposed to have all utilities on for that. Remedies, basically, if we get into a fight with somebody, or someone's not performing, you got to give a cure notice, and it gives them 3 days to correct it. If someone's in breach of contract, they will lose the earnest deposit after the cure period is expired. Dispute resolution, same scenario. If you get in an argument, everyone agrees to go through ADR. The only thing that doesn't have to go through ADR is anything that can be handled in a small claims court, which would amount to $3,500 or cheaper. Attorney's fees and costs, loser pays. Risk of loss, seller needs to maintain insurance on the property. Permission, both the buyer and seller grant permission for the agents to publicize their association with this transaction. It also affords the local boards the opportunity to gather data and be able to provide that to the public. Arizona law again supersedes anything that contradicts it in the contract. Times of the essence, if there's a timeline, all parties agree that they're going to go ahead and abide by it. Compensation, everyone understands they're going to get paid. Everyone's going to get paid for it. We are talking about copies and counterparts, release of brokers. They're going to hold us harmless in terms of acceptance as well. Okay. So that was just a quick cursory review. Now you would go through that. That's obviously required. You may receive a counter offer as well as multiple counters. So a multiple counter offer is in the instance where you have a bidding war going on. I'll cover this one first because we're running out of time, and this one's going to be a little more explanation that goes on here. So the multiple counter offer is you're giving both buyers. Now this is used from the listing agent now. So if you receive this, understand the situation you find yourself in. The seller is giving, say, two buyers the opportunity to meet their terms. The buyer is still going to have control of who they decide to go with. Okay. So it's going to be filled out. So this listing agent would say, hey, this is a counter to the original offer. List your seller, buyer, premise address, submit whatever your counter offer is, and you give acceptance here. Now then, let's just say that the buyer accepts it. Okay. The buyer can either respond and do a counter to the multiple counter, or the buyer can accept it.
So is this for not competing offers? This is just for, you get an offer and then this is how you respond?
This is for competing offers.
Competing.
So this is a multiple, this is when you're in a bidding war. So you have multiple offers. And listing agents use this to keep control of who you're going to sell to. Okay. So you could have like two people that come in and you like this agent a little better than this agent. And you want better terms for one or another. And that's part of some strategies that we'll talk about in another session. But this gives the control back to the seller. Let's say the buyer accepts it, right? Well, the seller still has final acceptance. Okay, so they've got two counter offers out. You know, as it sits, whenever you send a normal counter offer out, as soon as that buyer signs it, you're under or not signs it, but as soon as they sign it and deliver it back to you and give notice, that's when you're under contract. Here, the seller gets both of these back, one or both, and then the seller then decides who they're going to go into contract with. Okay, so then you would do that by seller's final acceptance. Seller's response basically means there's a counter, another counter to the counter offer. Okay, so we'll play some of these scenarios out once we get into going through the purchase contract. Whenever we do the purchase contract again, we're going to look at it a little bit closer, but we're also going to be looking at, from a negotiation perspective, how to utilize it to give your clients better opportunities. So that's the multiple counter. And if there's any of these forms that you guys want a little bit more in-depth study on, let me know. Hopefully I'm giving you a good synopsis of what's going on here. This one is pretty straightforward. Counter offer. So this offer comes in on a listing. It's the only offer you have in hand. Sometimes you would have a counter offer out and then you have another offer come in and then you use a multiple counter offer to both parties. Excuse me. You would retract the counter offer and present them now with a multiple counter offer. Does that make sense? So you have an offer come in, you counter them, you have another offer come in while that counter is out unsigned, then you would immediately notify the buyer's agent to retract it, that you're pulling that counter offer back and that you're going to be replacing that with a multiple counter offer.
Is there a form for retracting that, or you just have to just
give notice?
give notice?
Just give notice. Have your client sign it though. So just do a quick form up. We retract that. Have your seller sign it and send that out. But this one here is pretty straightforward. It's originated by the seller, and then you just kind of, whoever you're representing is, you're going to select that box. Counter, it's going to be either to the counter offer or to the original offer. Put your terms in, your acceptance. Be very careful whenever you receive these. Make sure when you queue this up in transaction desk, it's always going to go ahead. It will always put your signing in all these boxes. So remove the ones that aren't applicable. Response means we don't accept your terms. We're giving you another counter. Acceptance means we accept the terms. Be very careful not to send that out when you're trying to respond that they don't sign there. So I think time is up for Zoom. Give me one second.